to everyone who has joined us today for this session on the Protection of Personal Information Act, POPIA, POPIA, however you pronounce it. We know that this has been at the forefront of everyone's minds at the moment. So I'm Fiona Omar. I'm the content manager for practical guidance at LexisNexis. And I'm so happy to be here today to be chatting to you and facilitating this session. We know that this has been a very popular session. I mean, we are oversubscribed. It speaks to the fact that this is a very, very relevant topic. So just a few housekeeping rules before we begin. All delegates will be placed on mute. We will be having a short question and answer session. We are aware that we do have some time constraints to be worried about. So we will try to go through as many questions as possible. If you do have any other comments, please do share in the chat box, any general comments. And please do note that this session will be available to all of our delegates after. Okay, so now to begin at the topic at hand. As you are aware, LexisNexis has a proud, I'm not sure, I see that there is a comment from somebody who says that they can't hear me. Okay. Hopefully everybody can hear me. So as you are aware, LexisNexis has a proud heritage of helping our clients advance the rule of law. And one of the most far-reaching legal developments of our time is the introduction of the POPIA legislation. This new all-inclusive piece of legislation sets out to safeguard the integrity and sensitivity of private information as handled by a wide range of businesses during their normal operations. So we know that the deadline is fast approaching, and we know that there are going to be no excuses, no exceptions, and this means all businesses, big and small, need to have proper expert guidance in properly assimilating all the details of the Act and all of the implications therein. So we do know that with the deadline approaching and with a fine of 10 million rands or up to 10 years of jail time, this is something that is really causing anxiety. So today we welcome our guest speaker, Advocate Nicholas T. So Advocate T has been practicing at the Johannesburg Bar for the past 35 years. He is also very, very passionate about POPIA and GDPR. He also has an interest in land reform, land claims. And in his spare time, he also enjoys karate and is a speaker of the language of Romance, French. So welcome, Advocate T, and over to you.
Thank you very much, Fiona. Can you hear me clearly?
Yes, we can hear you.
Good morning, ladies and gentlemen, and thank you for coming on to this webinar in such numbers. I see it's maxed out at over 500, and apparently Zoom is limited to a 500 listing. It is being recorded, and it will be available to other people who try to log on at a later stage. What I'd like to do is just to correct one thing. I started at the Johannesburg Bar in 1989, so by my calculations, that's 32 years, not 35. Now, during the years since 2016, I've been doing seminars on the POPIA Act, and we are now changing the pronunciation of the POPIA Act to POPIA at the request of the regulator. Since then, I've noticed the one feature about the POPIA Act, POPIA, that people are not dealing with very clearly, and that is to read the Act. And so that is why you will see in coming slides, a lot of them are just quotes from the Act and I've got my special little piece of paper next to me. I'll be ticking it off as we go through points that I would like to highlight. The first thing I'd like to do is I'd like to put out a quick poll. Please, could you answer the quick poll which is coming up here? And the quick poll is, what is the information officer? Please, can I see, Josie, you can put on the poll now. While you're looking at that, please give an answer. There's only one right answer, and it's only half right anyway, but it's amusing to see what happens. The Chief Information Officer doesn't appear inside POPIA. So if you've marked Chief Information Officer, you're already wrong. The CFO, that is a generic term. It also doesn't appear in POPIA. The CO is a compliance officer. That appears in the COVID regulations. And the RP is the responsible party. That's in POPIA. So who is the information officer generally to be? Right, can we close the poll now and let's see what the answers are? Right, compliance officer, no, that is the COVID regulations. Responsible party, no. The information officer is generally the chief executive officer. Now, I want to speak about the chief information officer, and this is very important. The chief information officer is the person who looks after all of the IT inside an organization. So the CIO focuses internally, especially with big organizations. The information officer has to focus externally and answer to questions from the outside about what is going on the inside. And that is the chief difference, pardon the pun, between those two posts. So let me go on to the first slide, and I'll start by highlighting some of the most important features of this act. We know that the information officer is defined in terms of the Protection of Personal Information Act, and that particular definition is information officer in relation to a public body means the information officer who is contemplated in sections 1 and 17 of PIA, and then the private body means the head of a private body. Now, if you go to the next slide, you will see what I'm talking about, because there is the definition. Now, what I like about the definition is that for the public body, this document, which has been prepared by the regulator, which you can see over here, it's basically the guideline, is very well written. And save for Section 82 of the Municipal Systems Act, which has been repealed. But we don't need to deal with that specifically because the information regulator's document is very clear. What I want to do is to highlight, most importantly, what is meant by the private body and what is meant by the head of a private body. Now, if you go to the next slide, you will see that the head of the private body comprises 4 different animals. The first one is that natural person, including a person referred to in paragraph C of the definition of political party. And what I've added in there is that refers to a natural person who is an independent candidate for any political post, the independent candidate under the new rules. Now, I'm going to come back to that natural person. The second one is, in the case of a partnership, any partner or any person who's duly authorized. Now, the same thing is repeated in the juristic person. The chief executive officer, there's the answer to the poll, or the equivalent, or any person duly authorized. And it's this duly authorized concept which needs to be considered. Quite correctly, in my opinion, the regulator has said that when somebody at the top of an executive actually authorizes somebody else, you must not be authorizing somebody who's in the cleaning staff or the messenger staff. You've got to authorize an executive. And the reason why you authorize somebody in the executive is because This position is so important. The information officer is the top person in an organization for compliance with regard to POPIA. And the information officer is the person who is going to be more important in terms of accountability than even the responsible party. And I will be able to show you that in a few seconds' time. Now, when you look at A, in this guideline at 1.7, the regulator says quite correctly, the private body means a natural person who carries or has carried out any trade, business, or profession. So let me speak to my colleagues. I know that there are a lot of attorneys who are legal practitioners who are on this webinar at the moment, but there are also a number of advocates. An advocate is a person who's liable as a natural person under A, you are the head of your own business. What that means, your own profession. What that means is that groups of advocates in the bars, they must have an information officer for that part of the functioning of the group which relates to the employees. And then each individual advocate is technically required to be the head and is the head, and therefore the information officer for their own profession. And this is quite onerous, and we'll get to some other ways of dealing with it. Now, the next thing that has come up, and it's a very good question that has come up all the time. If you have a multiple collection of companies, they're all in a group, is it possible for the group to have one information officer and all the individual companies under it don't have an individual information officer? And the answer at the moment is no. You can't do it that way. Juristic personalities, since Lee versus Lee's Air Farming, I don't know if people remember that case from Australia, was the high point of the difference between a juristic person and a natural person. But the most important feature there is that at the moment, the Act is written in such a way that every single company must have its own information officer as long as that company is existing. Now, what is going to happen when SIPC deregisters a company for non-compliance with various of the rules, for example, of annual returns not being submitted? That company still remains liable to have an information officer because it's a deregistered company, but it still actually exists because it's still going to be on those lists of SIPC. So be careful about that. Now, there's another thing that is very fascinating. If you look at the definitions in the Act, person refers to a natural person and a juristic person. Now, all good lawyers understand that there is a massive gap there because trusts are not mentioned. Consequently, at the moment in our law, trusts are not subject to POPIA, and please don't let anybody fool you. Trusts are sui generis. We need an amendment urgently. For example, the Ingonyama Trust, which is so famous or infamous depending on your politics, is not subject to POPIA at the moment. That is an amendment that is needed. Right, please can we move to the next slide? The reason why I've put this one in is because it relates to the question of jurisdiction. Jurisdiction is very important because you can see it right at the bottom there. Where the information officer makes the decision, or where the public body or the private body concerned has its principal place of administration or business, or even whether the requester is domiciled or ordinarily resident, that captures jurisdiction in terms of POPIA. Thanks, we can jump to the next slide. Now, the responsibilities I've set out here, and I want to focus on the slide that follows because I know everybody can read the actual Act. The most important feature that I want to focus on the duties for the information officer is simply this. When you read the duties in 55.1, they're called responsibilities. The first one is A, the encouragement of compliance. And the regulator sets out what she thinks is the best there. The important one is D. It is the one that says otherwise ensuring compliance by the body with the provisions of this Act. Now that is where the locus of the absolute necessity for a good information officer lies, because they have to ensure the compliance. Now, in ensuring that compliance, the information officer has to make sure that the responsible party is doing its work, because the responsible party, as you know from reading POPIA, is the one that has to control the proper legal application of all of the 8 conditions of lawful processing. And we'll come back to that when I deal with the retention register. So that is where the buck stops. It's at 55(1)(d). That is where the information officer takes the primary level of responsibility for POPI. Now, ironically, the very next subsection is the one that says officers must take up their duties in terms of the Act only after the responsible party has registered them. Now, I know that on the website at the moment, the regulator is saying that there's quite a rush and the system is failing to register because so many people are trying to get their information officers registered at the moment. This is a characteristic of South Africans. We tend to leave everything to the last minute. And in fact, one of the big organizations, I think it is Business South Africa, BUSA, has managed to get the regulator to agree that with regard to the registrations of unique identifier numbers and all of that, in terms of Section 58, that has been transferred to the 1st of February next year. This is our South African pastime. We leave everything to the last minute. But I would urge people, try and get everything that you can registered and up to date by the 1st of January, by the 1st of July this year, because the last thing you want to do is to ask for extensions to December, because December is holiday time. And you really don't want to be doing your work during the holidays. Do it now, save the December rush, have a December holiday. Can we move to the next slide, please? Now, each and every public body must have its, information officer. When you try to get onto the site and you are using the same information officer inside a group, for example, as is happening with pension funds, they try to use the same. At the moment, the regulators' computers are rejecting that information officer. In other words, at the moment, what the computer technology is allowing inside the regulator is that only one person can be an information officer. Once that person's name and identity number are logged, then the system will kick you out if you try and do it again. I do realize, and everybody knows this, that some methods of organizing companies and groups cannot sustain an individual each time being a different information officer. But there is hope, and the hope lies in Chapter 4, and Chapter 4 of the Act is where you request exemptions. Now, I just want to say something very politely. People have seen it last year. When you request an exemption, the type of exemption you would be requesting in the context of the information officer is this. You are a massive group, but most of the companies are there for various different reasons, but actually are run by the same staff, the same board, the same people. Then you set that out and you ask for an exemption that you don't need an information officer who is a different human being, a different identity number for each of the many companies. You ask for permission to have one And then you can use deputy information officers spread across the rest of the companies. The trick about asking for exemptions, all good lawyers know this. When you prepare a draft order for a high court or a magistrate's court, the ideal way to prepare the draft order is to do it in such a clear manner that the court says, but this is manifestly useful, and I accede to the draft order. That is what the judge or the magistrate will say. When you approach the regulator for an exemption, keep it as limited, as pithy, as accurate, and as meaningful as is humanly possible, and the drafting must be impeccably clear and short. Do not ask for wide-ranging exemptions, and remember the reason why you're going to be doing this, particularly when you're advising big companies. Companies are in competition with each other. If your company gets an exemption on something inside POPIA, and that exemption has to be published, and other companies are upset, they have got a number of ways to deal with it. And one of the worst ways for the regulator is to start POPIA applications against the regulator to say, why have you favored this group of companies and not that group of companies? So what you want is something which will be the opposite of that argument, the thin edge of the wedge. In other words, you want an exemption because you are not setting a precedent, because it is so well based inside the confines of your particular reason for needing the exemption. Last year, you will recall there was the very famous FITA case. If you read paragraph 2, that's the only paragraph you have to read of the judgment by Judge President Mlambo and 2 other judges. It's on Safley, you could find it on LexisNexis and elsewhere. If you read paragraph 2, you will see why that case failed. It failed on the formulation of the notice of motion. So remember that when you go in for your exemptions. Make them clear, concise, and limited. May we move to the next slide, please? This last one I'm putting in here because it shows that the enforcement committee can deal with 2 parties inside POPIA when it is necessary that action should be taken against them. They list the responsible party first, and they're the information officer or the head of the private body. So I want to go back to a general principle which I agree with in the regulator's comments. When you put in a deputy information officer, or when you authorize somebody to act in that position or to act as an information officer, keep it at executive level, because these are important positions in the Act. Right, I'm not going to carry on any more about the information officer. Let's move to the next topic. I want to deal with the retention register. Now, a retention register is done in terms of sections 13 and 14 of the Act. And the reason why the retention register is important comes to the very essence of POPIA. And if you move to the next slide, you will see that the retention register stems out of a feature of the preamble inside POPIA. And the preamble starts off saying, recognizing that section 14 of the Constitution provides that everyone has the right to privacy. The second part is the right to privacy includes a right to protection against the unlawful collection, retention, dissemination, and use of personal information. And then if you read a little bit later, and bearing in mind that, consonant with the constitutional values, there is a need for economic and social progress and a way to remove unnecessary impediments to the free flow of information. And there you have the essence of POPIA. On the one side, the protection of personal information, and on the other side, the free flow of information. And that is, the free flow of information is in the market and the protection is personal. Now, we can't go into the fullness of why this conflict exists, but you do know it exists. And in previous seminars and webinars, I've dealt with it under the ancient Greek thinking of thesis, antithesis, the two collide. And the way to deal with understanding this act is that the two then, having collided, form a synthesis. The essence of the adversarial system is the same. Plaintiff, defendant, the judge makes the judgment, the synthesis. Now that is conflictual thinking, and that level of thinking needs to be done by the responsible party, particularly if in big organizations. And the responsible party ideally shouldn't be a single human being, but rather a committee, particularly for big organizations, because more heads are better than just one. No person can know everything in the modern era. There is another way of thinking, and that is the way of thinking that is called mediation or mediatory approach. We also know that in terms of the new Rule 41 capital A of the Uniform Rules of Court, that is becoming more and more important. And that also has to be taken into account when applying POPIA, particularly through the responsible party. Now, the mediation approach, we learned at school in the Venn diagrams. You'd have a circle filled with numbers. You'd have another circle filled with letters of the alphabet, and the teacher would say, draw the overlap. Where is there anything that intersects? And you would say, but there's no intersection. Then you would put another question before, and it would be a line. There would be letters and numbers, and in the next line down, numbers and letters. Note the nuance. Then you have to draw the overlapping circles, and you have to place them. That function that we learned at school is the mediatory function, because the purpose of the mediator is to try and expand that which overlaps. So the mediator goes to A, goes to B, goes to A, goes to B, and tries to expand the overlap. That too is part and parcel of the POPIA thinking. And the responsible party needs to know this. And then the last point about this. When you are dealing with POPIA, you're dealing with principle-based legislation. Principle-based legislation is not a tick box. I'm going to get to the tick box in a minute. The tick box is in the retention register itself. But principle-based legislation requires that people debate and understand what is the purpose for keeping that personal information. And in the process of debate, one of the best examples of debating where you can debate and disagree without being disagreeable is in the Ascenders case, which happened in the Constitutional Court. It so happened that 10 judges were sitting in that court, which is not wise, because it should be an odd number. You can see what's coming. The Supreme Court of Appeal, the appellant lost, applied to the Constitutional Court for leave to appeal. 10 judges said, yes, you have leave to appeal. 5 judges upheld the leave to appeal. 5 judges dismissed it. Dead heat in the highest court of our land. That means that people can disagree about law topics inside POPIA reasonably without being disagreeable. And that is so important, because this legislation requires people to use their noggins, their understanding, not to fight. Fighting is not the route through this act. And so, of course, just for the lawyers, obviously, if the appellant to the Constitutional Court failed, the decision of the Supreme Court of Appeal is the one that is the last one standing. Josie, the next slide, please. Now, these are parts of the condition 3, the purpose specification, and I really want just to focus on this. In my opinion, but it's my opinion, the best way to understand POPIA from beginning to end is to start with your purpose specifications. Now, in a number of lectures and various other documents which are on the LexisNexis websites and on their, in their project products, and which will be in a new product which is being developed at the moment, and Fiona will talk about that presently. I have done graphs and tables which I've drawn from POPIA. Now, POPIA is Canadian, and the Canadian government website has various toolkits of how to understand their equivalent of our POPIA. And in the approach to doing that, I've also taken our legislation and then asked questions copycatting the approach used by the Canadian government. If you go to the next slide, you will see that is what's going to be, that is why you need a retention register. Now, to cut a long story short, in that retention register, I just want to highlight section 14(1)(a). It's the essence. The retention register is a record of what is required or authorized by law. All the rest, yes, it's there, but that is why you must have it. And then the responsible party, later on, right in number 4, sorry, on the next page, number 6, must restrict. The responsible party must restrict information where there is some form of a dispute. So let me go to, now this, you're going to be amused by this. POPIA, I didn't tell you, is the Personal Information Protection and Data and Electronic Documents Act. But the next slide is an idea of what your template will look like for a retention register. And this comes from FIPA. Now, this is also Canadian, it's from Ontario. And this stands for Freedom of Information and Protection of Privacy Act. And these are the types of things that, that are posted in the Canadian websites to give you an example of what is going to be in your retention register. So if I go through the register here, the record type, the record description. Now, most importantly, you've got to know whether you're keeping personal information. So on each category, you say, yes, you're keeping personal information, then that's a hotspot. No, you're not keeping personal information. It's not a hotspot with regard to POPIA. Then you've got to know how long you're retaining it. And your retention period is according to law. Remember that what I've just quoted you now, and I'll come back to this because it's an important one. That retention period depends on different statutes. It depends on a whole host of things like codes of conduct. It depends on the different regulations that apply. It depends on practice. And one catch-all, if you are an organization that requires to keep your data for as long as possible, for example, university, or you're a library, then you're entitled to keep that, but you've got a good reason to keep it because you know why you're retaining it. Now, the trigger event there is what starts your retention period. Now, sometimes people say the trigger event is what ends your retention period, but that's up to you, whichever way you want to do it, because I've added in there the action taken. Once your trigger event has started, you know your years are running for how long you can keep this information. And I want to give you a practical example. POPIA is principle-based legislation, but the Basic Conditions of Employment Act, that is a tick box exercise in section 29. We know, and people find this very difficult to understand, that you can have an oral contract of employment. The only problem with an oral contract of employment is that it's not worth the paper it's written on. And so that is why Parliament put in section 29. So if you have an oral contract, you've got to have everything that's listed in section 29. You've got to tick it off, you've got to have it in your drawer. Why put it in your drawer? Put it into a written contract, then you've done both at the same time. That's the tick box exercise. Now, when an employee leaves your employment. According to the Basic Conditions of Employment Act, you have to keep their information for 3 years. Your trigger event, 3 years from the date of leaving the organization. And then action taken after 3 years, you remove the personal information from your systems. General notes, well, that will be anything that you seek to put into general notes. Thank you. That's the end of the retention. There are some notes that I've put in concerning how you read the retention register. You will be getting these things, and it's not difficult. It's also going to be part of the new products that LexisNexis is about to launch. Right, let's go to the last topic, because my helper, who's sitting next to me and is my timekeeper, has told me I've got 5 minutes left. Right, formulating a breach plan. Can we then go to the first slide? Now, I want to say something really important about what's going on in South Africa about POPIA. This idea that you've got to fear the act, that there's going to be millions of rands in fines and 10 years imprisonment, it's all nonsense. That is the fear-mongering. The reason why you want to comply with POPIA is because it's actually good for the economy. It's good for your business. So the approach, I suspect, and I hope I'm right, that the information regulator of South Africa under POPIA is going to use is going to be analogous to the, and I've got the website address, the Information Commissioner's Office of the United Kingdom. ICO is their website. Now, the Information Commissioner's Office in the United Kingdom applies the General Data Protection Regulation, and they're going to carry on applying it despite Brexit. But that website and many of the statements made by the Commissioner are requests to people to comply, and their requests are basically the carrot, not the stick. So when people say it allows 10 million rand fine and 10 years, that is not the approach that our regulator is going to use. What we need, particularly for the legal profession, we know that Lord Peter Hain, and this is a political statement, so those who want to tune out, you can tune out for a second or two now. We know that Lord Peter Hain came to the Zondo Commission just before the COVID. And he mentioned that there were 3 professions that were the enablers for state capture. They were the legal profession, they were the accounting profession, and the banking profession. So let us not, as lawyers, start carping against POPIA. Let us rather have an approach that confirms POPIA's position in our constitutional dispensation, and let us get people to comply voluntarily. And remember, people have to debate why they're keeping that information, and we know from the Constitutional Court in the Ascenders case, people can disagree without being disagreeable. So that's the end of the political statement on that. Now, if you go to the next slide, the most important feature of understanding the security safeguards is that you must read section 19. I'm running out of time, so I'm not going to go through the details there. If we can go to section 20, the next slide, you will see that your processing has to be done, and you have to treat everybody there as if they're part and parcel of the responsible party. That means that the responsible party who uses an operator for processing must have a written contract and so on. The essence, though, is in section 22.1. So if we can jump to section 22.1, it's to play another slide. I just want to highlight that one. Okay, section 22.1. And the reason why I want to highlight this part is because this is really the difficult one. Section 22.1 reads, where there are reasonable grounds to believe that the personal information of a data subject has been accessed. Now, I'm not even going into the rest. That is the key. Now, access can happen in three main ways. It could be a white hat, a gray hat, or a black hat access. Now, big organizations use white hat hackers, and they do it in a number of ways. They can be permanently employed, which is unusual, but the CIA and various international security organizations like that do use permanent hackers. They are white hat hackers, and their job is to enter into the security systems, bypass everything that you've got, using zero-day attacks, which means the first time that the attack is used, and to try and then get into the system, and then to tell the employer what they did and how they did it. Banks in South Africa need to do that a lot, and I do know that some of the banks have not permanent hackers, but people who are there to hack on one particular project and then a product, and then on another particular product. So the white hat hacker is in breach of section 22(1) because they've accessed. That's important. There's the breach. They're already in. So when you have a white hat hacker, you have got to inform the regulator that you are doing a white hat hacker, and the white hat hacker got in, but nothing was lost. The regulator has to know that. The gray hat, now these are people who are a little bit outside. They hack, but then they come and tell you, this is the route we hacked you, and this is what we would like you to do. Would you like to help get us to employ us? Would you? And so the gray hat is a bit. The black hat hacker, that is the one where you've got to have data systems protection. And now, most important about this act, we don't have, I'm not going to put on a screen here. Your job inside security safeguards, wherever you are, is to make sure that you've done everything reasonable. So if I give you just basically a list, which I'm going to read off from my other computer over there, you've got to keep your system software updated. You've got to implement endpoints protection. You've got to use secure internet connections. You've got to have secure web browsing and email. You've got to have a data loss recovery system. All of these things you have to have. We don't have time to go through these. You've also got to have a way of not allowing people to hack your system so easily as coming to your reception. And this is the one that is used a lot. People who have a good reception, the purpose of the reception is to interface between the office and the public. And the design of a reception is to have receptionists who are friendly, cordial, and polite. So somebody brings a flash drive and comes up to the receptionist and says to her, I'm so sorry, I'm late. I've only got a 3-pager that I need printed. Please, would you print it for me? Here's the flash drive. And of course, the receptionist, being polite, puts it into the computer at the reception and prints, gives back the paper, gives back the flash drive. If that computer at your reception is connected to your network, you are compromised. And that is not wise. So security safeguards go down to that level. Security safeguards also go down to, dare I say it, I've lost my iPad. It's been stolen. Actually, I don't have an iPad, but anyway, you know what I'm talking about. So these things happen. What you need there, if you can afford it, but you should be able to afford it, is you have some form of system where it effaces everything on the lost computer, the lost iPad, and the lost iPhone. And then the last thing, the theft of iPhones in South Africa often happens where people in these, shall I say it, Toyotas, drive past pretending to be Uber drivers and the poor soul waiting for the Uber, and suddenly the phone is snatched out of your hands and the Toyota goes away. Not an Uber driver, not an Uber driver. Now, this also happens in the rest of the world. One of my computer specialist nephews was walking in London on London Bridge. He was talking on his cell phone, talking back home to his wife, which is very nice. And two men on a moped came past, one driving very carefully and the other snatching. He lost his iPhone in London. So it happens. But he's a computer specialist. By the time he had reported it, the information that was sensitive on it had already been effaced. Those are the levels of security safeguards which people need to take into account. Can we go to the next slide? Right. There is the notification that you have to do. And then if we can go to the next slide, I want to go through this last slide just briefly. I mentioned earlier the General Data Protection Regulation. That came into operation on the 25th of May 2018, and it replaced Directive 95/46 in the European Union. Now, this is just a comparison of the different terms that we use. So in POPIA, you can see I'm still a bit old-fashioned. I called it the POPIA Act. Sorry about that. In POPIA, we protect personal information. In the GDPR, they call it personal data. In POPIA, we have the information officer, which comes out of PIA as well. And there they have the data protection officer. We have the responsible party. They have the controller and or the processor, because they're a bit blurred. We have the information regulator. We have operators, and operators are the same. And we have the information regulator, and they call them supervisory authorities. And that is a basic slide to see the similarity. Last point. This office of the Information Commissioner's Office, that website is magnificent. And there is something in that website which is priceless. They have a Q&A. The Q&A deals obviously with the GDPR, but the concepts that are used in the GDPR, they're 6 principles as opposed to our 8 conditions. They are all so similar, and they ask questions. And if you are stumped by wanting to understand, for example, what is consent? Go onto that, look at their drop-down menus inside the questions and answer section, and it will save you hours of heartache. Thank you, people. That's what I have to say today.
And thank you so much, Advocate T. That was really, really informative. Moving on, I think what we are going to try and do is try and answer as many questions as we can. We do realize that we are going quite close to running out of time, so let's try and answer as many questions. Let's start off with, someone is asking, what is a privacy impact assessment?
Okay, the privacy impact assessment is very similar to your data mapping. What you want to do is you want to see how exposed you are and what is your risk of how much information you are keeping and the risk of how that information can be accessed. So in your privacy policies that will be on the internet, the way in which you're going to be dealing with those is, firstly, you're going to say what type of information you keep. You're going to tell people where your cloud servers are. That's very important, because that brings in Section 72 of the Act. And your cloud servers are unlikely to be in South Africa. People do not realize that the Zoom function that we are on now is going through Beijing. If you're on MS Teams, it goes through Seattle. So those sort of roots of the way in which information flows around the world need to be known. If you have cloud servers that are in St. Petersburg, you might be a little bit more worried about their probity compared to those that are in the United States or in the European Union. Those decisions you need to take, and you need to know why you're taking them, because that's your downside risk on privacy hacking. But they're also political decisions, as you can imagine, because there are those who prefer the authoritarian approach of China to the more open approach of the European Union. And you can see this battle, and it's been dealt with in such detail. It's fascinating if you've got the time to read it, about social media and how social media is driving the world into two camps, different opposing camps. And this is one of the reasons why it is so important for us in dealing with POPIA to get people not only to do the thesis, antithesis, synthesis clash, but also the mediatory clash. So when you're writing your POPIA policies, you've actually looked at the privacy concerns of everybody inside the organization. That's your privacy policy.
Okay, thank you. Next question. In an NPO, do you only have one information officer, or can you have deputies?
You can have deputies as well.
Okay, next question. How detailed does the register have to be? Can it merely set out categories of documents?
It can.
Okay. Next question. Is it possible to store information not within the suggested table? In essence, do we comply with the Act if the storage of information is fragmented into smaller components? For example, tagged by a property file.
Oh, no, that's fine. That's fine. That's fine. As long as you're storing information safely, you're fine. And you know where it is. You must know where it is. There's a good point there. There's just a good point there. In this presentation, I've concentrated obviously on internet security. There is obviously another level of security that you have to have. If you've only got hard copy files, you have to store them so that they don't get destroyed by fire or water, because if they do, you have to report yourself to the regulator. So storage is not only computing, it's also the physical hard copies. And you also can't have those physical hard copies in a vulnerable place where somebody can walk in with a big lot of files, but they're empty, and then walk out with your files because they're now full. So you've got to have that sort of security as well.
Okay, perfect. Next question. To explain to a layperson who owns a business and who is afraid of non-compliance, what are the basic requirements for compliance?
Get a good attorney.
Short and succinct.
Yep, get a good attorney. No shortcut.
Okay, we have heard of information officers, etc. What happens in the case of sole proprietorship? Do we ask for exemption to be allocated as the relevant official responsible person in POPIA? So,
I don't think you can try for an exemption. I don't think you'll get it because the Act is pretty clear. If you're a sole proprietor, like an advocate, you are your own information officer, and at the same time, you have to be your own responsible party. There, it's one of the few places where the two concepts overlap.
Okay, and let's take one last
just on that point, for advocates, I know I've been responsible for this too. Sometimes our desks are in a mess, and sometimes our attorneys take away files that don't belong to them. That's a no-no in POPIA. Be careful. And sometimes the attorneys do it on purpose. Be careful of that too.
Okay, and one last question, Advocate P, that we'll take before trying to swiftly move on. will the registrar take off the files of a person who has left the company and was the information officer?
You have to deregister that person from the information regulator. The regulator is not going to know it without being told. And let me just get one little point here. Everybody tends to say that Advocate Panzigakula is the information regulator. Actually, technically, she is the chairperson of the juristic person, which is the regulator. Her term of office ends, I think, at the end of November this year.
Okay. So thank you, Advocate T. And we do apologize for not being able to get through all of the question and answers. We are quite hard pressed for time. Quickly before moving on to the next segment, we have seen an overwhelming interest in this topic, and LexisNexis does have a range of solutions, and we are seeking to improve that with your feedback. So we would like to actually host a poll and get your feedback, please. And there we go. We would really appreciate all of you answering these questions. Okay. And next, we'll also be introducing Daisy Gounden, who will be doing a demo on some of our POPIA solutions. Advocate T has been writing for us in terms of POPIA for IT and data protection for practical guidance. He is also writing some content for us for a POPIA solution that we have that will be available as well next week. So over to you, Daisy.
Thank you. Good morning to everyone. Thank you very much for the opportunity. And thank you, Advocate T. That was really interesting. I am going to share my screen, everyone, just very cognizant of time constraints. And right now I'm going to share the screen, which takes us to the practical guidance solution. So please note, aside from Lexis Library, we have several other platforms, 3 other platforms, in fact, that can support you in your understanding, to be able to decipher what POPIA is about and how to observe the obligations pertaining to this legislation, and would really assist you to indemnify against, any of the breaches that could possibly happen. So here we have, under the practical guidance, the IT and data protection module. And I really want to draw your attention just to where it is found in the IT and data protection module, where we see the data protection topic area here. And then we have the international data protection, the GDPR regulations there. This product is just absolutely incredible, everyone. As you scroll down into it, you are able to see the various headings. You are able to drill down into content. You also have, to the very right of this product, in fact, even on the landing page of this, on the very home page, you will see the latest alerts on this product, the latest news items. But just a wonderful, wonderful way. There's the what's new here. And if I just simply click into a heading, I want to do a very quick top off on this. Notice how this product works as a solutions-based product, providing a guidance note and also the references, which then speak to the specific sections that are applicable, including anything that is overarching when you are speaking to those areas, those guidance or precedents of the legislation and the requirements with which you need to, by which you need to comply with. Now, when I go back just very briefly here, and I don't have the time to go into each one, but please, I'd like you to take note that we are really bolstering the amount of content that we have specifically in this regard to POPIA. You'll notice at the bottom of the practical guidance modules, you have this POPIA toolkit, which is about to be released, as Fiona Omar has highlighted. And this is going to be a brilliant toolkit and another practical guidance module that will speak specifically and more in depth to all of the legislation, including the overarching legislation. So don't forget Lexis Practical Guidance, providing you an in-depth breakdown, step-by-step process of how you unpack and how you process data protection within your companies and the different entities. And of course, today here we have many people in the audience, quite a wide spectrum of people. We have representatives from the legal fraternity, from government offices, audit firms, municipalities, revenue, SARS, banking, judiciary, the Office of the Auditor General, financial services. So such a wide range, too many to even mention, retail as well, academic institutions. So there's so many that have gathered here to hear about this, and that tells you how important this is to every single person, every single one of us. And I want to share another screen. I'm hoping that I can get to this swiftly, just to touch on another product that we have, and I'll even start talking it through, which is the Lexis Assure product, and that is an alerting service. So everyone, if you'll just bear with me, I need to just share this screen. Fiona, if you'll tell me if it's coming through, please.
Yes, it is.
All right, lovely. So there we go, everyone. Now, this is the Lexis Assure product with its alert service, and those alerts link to your email. So an incredibly wonderful way of receiving an alert, anything to deal with the selected acts that you have taken, and in this instance, say POPIA, you and all the surrounding legislation, you would then be able to monitor and to track this. So Lexis Assure, another product that we offer. And under the tab that I've got opened is this option to have, your compliance build up of this actual act and the breakdown of the act into these headings by the category, is it core or primary legislation, and to be able to monitor and mitigate that risk into, is it inherent, is it residual, and also to track and monitor the status. Please, everyone, our timing does not allow for me to go into depth, but I really want to encourage you to get hold of an account manager or a salesperson, as you might refer to it, one of our sales consultants, somebody in our team that could offer you this product and showcase all of the different product solutions that we have. And with that, just the very last one that I have is we have a product called Lexis GRC, which is governance, risk, and compliance. It's really your end-to-end robust compliance solution for a comprehensive, as we say, a reputation protection offering. And it will monitor and track and guide you on governance, risk, and compliance. So that's the type of software that we offer. So 3 products that I've mentioned, everyone. 1 is the Lexis Practical Guidance, 2 is Lexis Assure, and the next one is Lexis GRC. And that's over and above our usual Lexis library. So thank you, everyone. I'm going to hand over to Fiona. Thank you very much, Fiona.
Thank you so much, Daisy. That was great. Everybody, thank you so much for your patience. We do understand that we have run past the time slot. We want to thank Advocate T for making time today, for all of his insights, for all of his advice. It was great as well. Please do stay and view our special offers that we are going to be offering on screen, that are going to be available to all attendees of the session. Please also remember that this session is being recorded and will be available to all delegates. So we thank you again. Stay safe, stay well, and hope to connect soon. Goodbye.